Michigan Justice Chronicles with Dan Geherin takes you inside the courtroom and behind the scenes of criminal defense law, uncovering the strategies, stories, and stakes that define justice in Michigan.
Welcome to Michigan Justice Chronicles with Dan Geherin. I'm Sam Henninger. I'm excited to talk to Dan today because we're going to dive into a particular case that he has a unique perspective on as a former prosecutor, criminal defense attorney, and juvenile justice specialist. So Dan, I'd love to get your sense. What can you tell us, your insights about the Oxford High School shooting case?
Yeah, Sam, if I, as the saying goes, had $1 for every time someone asked me about that case, I suppose I'd be a very rich man. But I think there's a reason for that. Here in Michigan, the Crumbly case, or the Oxford shooting case, was one of the biggest cases in Michigan justice history, if not the biggest, for a lot of good reasons. Not good, but understandable reasons. And yeah, I think I have a bit of a unique perspective. Not only have I been a prosecutor, but I've been a criminal justice attorney for 2.5 decades. And a lot of my practice area from beginning to end has been in juvenile justice. And so I'm happy to talk a little bit about it. For those that don't know, sadly, a young man named Ethan Crumbly at the age of 15 walked into his public school in Oxford, Michigan, around Thanksgiving of 2021, shot and killed 4 fellow students and wounded many others, including a teacher. After he was apprehended, the police did some quick research and found out that the gun that he used had been bought for him 2 days before by his parents, had been left out or not properly stored, and that there were many warning signs, which I'm happy to go into, that the parents should have seen in not only not buying him a gun, but perhaps not allowing him to go to school that day, that might have stopped those killings. And so the Crumbly case, the Oxford shooting case, has a lot of interesting elements in my practice area: juvenile justice, parental responsibility, manslaughter, gun rights. And so I'm happy to talk about all of that.
You gave a very brief synopsis of what happened, but tell us what the outcomes were of the case for both the juvenile, Ethan, and his parents.
Your timing's impeccable, Sam, because literally within the last month, the entire cases have resolved. First off, Ethan, in sort of a unique twist of fate, pleaded guilty to first-degree homicide or murder, which doesn't happen very often. In fact, maybe once in a 25-year period, because when you plead guilty to first-degree murder as an adult, typically you get life without parole. There's no other exception. Now, he had the slight chance of avoiding that because he was a juvenile charged as an adult, but lo and behold, the judge gave him life without parole. So he's probably 17 now, and if we follow the life cycles here and he lives till 80 years old, he'll spend the next 73 years, or whatever the math I've done, in prison without any chance of being paroled. So that was his punishment. Both parents went to trial separately. First, the mother, Jennifer, was convicted by a jury of manslaughter. Then her husband, James, was convicted of manslaughter, and both of them received an identical sentence, which was 10 to 15 years in the state prison system, which itself, Sam, is unique because that's the maximum sentence that was allowed by law. You typically don't see people get a maximum sentence on their first foray into the criminal justice system, but you can imagine on a high sensitive, high media case in which it was the first of its kind. To be clear, they were the first parents in United States history to be prosecuted following a school shooting for their kids' behavior. So they were given the max. They were maxed out. And those all just occurred within the last couple of months. Obviously, there are appeals going back and forth. But as we sit here today in May of 2024, the parents and the kid are all sitting in prison for their various activities in this sad case.
Very sad. But what can you tell us about how those cases with the parents actually unfolded? Because you said that this is rather unprecedented, and it sets, I can't even imagine the implications of it now.
There's no question. I do recall when the prosecutor in Oakland County, Michigan, charged the parents, there was sort of this outcry by those that frankly do what I do for a living. A lot of defense attorneys were outraged that the prosecutor would charge parents for the actions of their child. And I saw it a little bit differently. To me, and a lot of people that practice both civil and criminal and wrongful death and so forth, thought there was a pretty significant link between what the parents did and didn't do and what their son ended up doing in those hallways. And to simplify it and to summarize it, Sam, What happened was not only did they buy a 15-year-old kid a gun, which is not per se illegal at the time, but they just didn't secure it. And this was a kid that was really, in my view and in the view of the prosecutors, suffering some mental health crises that the parents sort of looked the other way on. To me, though, the most damning fact, and when people that are unfamiliar with the case hear this, their head spins around. The morning of the shooting, literally an hour before the shooting, the math teacher found that Ethan Crumbly was scribbling on his math homework images of guns and of blood and talking about the thoughts won't stop. She reported him to the principal. The parents were called to Oxford School. They met with the counselor. And rather than saying, you know what, we just bought our son a gun 48 hours ago, rather than saying, we're going to take him home, rather than saying, hey, Ethan, do you have a gun in your backpack? They went back to work and left their son in school, who walks into the bathroom and an hour later pulls out that gun and massacres 4 of his classmates. So that was one of the linchpins of how the prosecutor showed that what they did was involuntary manslaughter. They didn't warn. They shouldn't have bought the gun. They should have secured the gun, and they should have taken different action than they did, which might have resulted in kids not being killed.
Dan, as you describe it, my heart breaks for everyone involved. I have no words, but let me ask you, what are the implications now that this has been decided?
Yeah, it's a great question. And I think one of the first things the prosecutor, Karen McDonald, talked about in her press conference after the convictions was, she was not looking to set precedent. They were just looking to prosecute people that they believed were responsible. And I tend to take her at her word for that. But I think now that there's been convictions gained in these cases, I do think more prosecutors will think about charging family members or parents when there are these mass shootings, especially where there's negligence involved in providing a gun and things of that nature. And I would hope, and maybe this is just a societal type of discussion, I would hope it will deter other parents from being negligent, from maybe not providing their child with a gun until they're old enough to be mature enough to handle the gun, maybe looking for warning signs in their children before they provide a weapon. And I think there's a deterrent effect. I do think that there's some precedential value because, as I said, the next one won't be the first. And so it will be easier, I think, for prosecutors to bring these charges when there's these tragic shootings or tragic mass killings, and then there's negligence on behalf of somebody in the background.
So to be clear, do you think we'll see more parents being prosecuted for school shootings in the future?
I think probably yes. The reality is these kids usually have access to a weapon that typically comes from inside the home. And I think if parents are not more careful in securing those weapons and allowing access to them, you're going to see similar prosecutions to what we saw with Crumbly. And I said a minute ago, I think once that first domino falls and other police agencies and prosecutors across the country say, oh, well, they did it in the Crumbly case, I think there will be more people charged, more people to answer for these horrible acts than just the shooter themselves.
Now, I'm thinking about how things work for you in Michigan surrounding the age of jurisdiction for criminal offenses and how this affects how cases are handled.
That's a good question. And it's also a timely question, Sam, because number one, there's been a recent change in the law. And number two, the Crumbly case is a good example of this. In 2021, finally, Michigan joined the grand majority of states in increasing the age of jurisdiction to the age of 18. So now, if someone is 17 years old and 362 days and they commit an offense, in Michigan, they'll be charged as a juvenile, and rightfully so. If they're 18 years old in 1 day, they'll be charged as an adult. Up until 2021, Michigan was 17 and under for juvenile, which was this odd dichotomy. You would have a senior in high school, and we had plenty of them charged with an adult crime, going to adult jails, and it just didn't feel right. So Michigan increased the age. It was called the Raise the Age legislation, and that is now full law in Michigan. And to use the Crumbly case as an example, you may have heard me say, Sam, that Ethan was 15 when he committed this offense, but he was an adult because he committed homicide. And Michigan has a series of what we call waiver offenses, the most serious of serious crimes, that if juveniles under the age of 17, 18 commit, they can be charged as adults. Now, that doesn't get into people who are 12 and 13. There's always going to be interesting legal dilemmas on that. But if someone is 15, 16, 17, commits a homicide, in the grand majority of cases in counties in the state of Michigan, they're going to be charged as an adult. And then we get into the sentencing, whether they are sentenced to an adult type sentence. The judge has to conduct a special hearing, as they did with Ethan Crumbly, called a Miller hearing, where the judge has to determine whether that's cruel and unusual or whether that's an appropriate sentence. And here, the judge decided that life without parole was appropriate, was not cruel and unusual, and that is why Ethan Crumbly, absent an appeal, will die in state prison in Michigan.
Now, in previous conversations, you had described how a key difference between adults and juveniles is that we focus on rehabilitating juveniles, whereas for adults, that might be part of the plan, but not the focus. How has representing juveniles been different for you in your experience?
Well, I think you use the right word. I mean, there's always going to be a sadness element to a juvenile case, especially a serious one like Crumbly, right? I mean, it's sad as much as you want to hate the kid, of course, that killed classmates. There's got to be some sadness in the idea, where did he get to that point? How did he get to that point? So when you're representing a kid and they are facing the rest of their life in prison, it's going to obviously be a sad and difficult representation. So there's going to be the age sort of feel to that. And then there's going to be the different factors and different procedures, right? If I, as an adult, kill someone and I'm found guilty of first-degree murder, it's life without parole. If a juvenile does, I mentioned a Miller hearing and all the factors that a court is to consider. And that's sort of set, for example, to make sure that minors are rehabilitated, that there is a rehabilitation effort, and that they are balancing the societal need to lock someone away versus the fact that a juvenile's brain isn't fully developed, the fact that they might have a shot at redemption, and so forth. So representing juveniles in waiver offenses, the most serious offenses, yeah, that's a unique perspective. You've got a kid facing a very serious offense. You've got the parents and how the ethics go in with their ability to be a part of the representation. And then you've got the different policies, procedures that are markedly different from adult prosecutions.
So what are some of the more common offenses committed by juveniles in Michigan? And how does the system typically address these offenses?
Yeah, I have raised two teenagers, and knock on wood, they've both not gotten any trouble. But for the grace of God, go I, as I say, because I do a lot of talks at local high schools for football teams and athletics, and we talk to young people, and we sort of tell them to keep in mind that there are really four areas that juveniles find themselves in trouble statistically more often than not. One is substance abuse, right? The drinking and the use of marijuana and things that minors simply aren't allowed to do. And so you get a lot of kids that find themselves on the wrong side of the law, delinquency charges for use, possession, or drinking and driving. The second are driving offenses. You got a 16-year-old, he's not been driving long. Invariably, there's going to be texting while driving. There's going to be drinking and driving. And then sadly, I've represented a lot of juveniles who, just because of inexperience, hit and kill or injure severely other drivers or pedestrians. And so you're going to have some serious, what we call negligent homicide and reckless driving causing injury cases. So we've got substance abuse, you've got driving offenses. Then you have a lot of the sex type offenses, sexting and sexual harassment and sexual assault cases that occur not only amongst young people, but on college campuses that are close to juveniles. And so there are a lot of those. In fact, you'd be shocked to learn, maybe not so much, here in Ann Arbor, our juvenile court has a specialized docket, a docket that only handles people who are charged with what we call sex offenses. And that's once a week, specialized docket, specialized court, resources for treatment and counseling and rehabilitation to make sure it never happens again. And so that gives you an idea how prevalent those charges are. And then last but not least, you have a lot of property and theft offenses. Kids get mad at each other, they key cars, they toilet paper houses, they might damage each other's property. And so there's a lot of theft and property offenses, retail frauds, shoplifting, things like that. I would say 90% of juvenile work fall in those four categories. And then you have those sad, as you said, infrequent waiver offenses where kids are committing murders or criminal sexual conducts or kidnappings and things that are rare, but unfortunately and sadly common as well.
Now, we've talked in this conversation and previous ones a bit, again, about this distinction between juvenile and adult cases. So when it comes to sentencing after a decision is made, what are the sentencing options for juveniles convicted of crimes in Michigan?
So divided into two camps. Number one camp is if they're not on a waiver offense and they're a traditional juvenile, There's a range. I always tell clients to think of it like a ladder. On the top end of the ladder is they can be put in a juvenile facility, and these are basically juvenile prisons. There aren't many of them left in the state of Michigan due to funding, but a juvenile can go to prison if they commit a serious enough offense as a juvenile. They're called a ward of the state. The state essentially takes over their supervision for a number of years. That's the top level of the ladder. From there, you have facilities like treatment facilities. Someone could be removed from the home and put in a drug treatment facility or a anger management facility or so forth. And then you have the more common probation. Juveniles can be given probation. They can be put on probation with monitoring and things like that. They have to do rehabilitation courses, community service, and the like. That's clearly the most common. And then at the lowest level, we have diversion offenses where they're earning a dismissal of their charge through sort of informal supervision or probation. Now, for people that commit a waiver offense and they're treated as adults, then it goes into the adult system and they're treated no differently. They're facing state prison. They're facing local county jails. They're facing probation by adult probation supervision. So waiver offense is different. The majority of juvenile sentencings, or what we call dispositions, are going to fall in that sweet spot of home probation or probation outside of the home.
Makes sense. Now, I've had some personal and professional experience in social work working with male juveniles who have been wards of the state and then moved into facilities. And the opportunity there for them was, if they complete that program, do what needs to be done to make progress towards being a productive person in society again, being trusted again, that their record of the crime could be expunged or erased. And so is this always the case, that a juvenile convicted of a crime will have a record that will just follow them for years? And how does that system address the potential for rehabilitation and future opportunities?
Yeah, in Michigan, we do this strange sort of word play. A juvenile is adjudicated of an offense as opposed to convicted, but it's the same darn thing. And there's even a public record. They're ordered to get fingerprints. There's a Michigan criminal history search that can be reached publicly. Now, Michigan has done some interesting and creative and smart things over the past 3 years to start to close that loophole. One, they've limited public access to juvenile records. It used to be you could go to juvenile court and pull any file you wanted. Now you have to have a legitimate interest in the case. You have to be a party to the case to see that. Cases are generally closed to the public, even if they're conducted by Zoom. The other thing, Michigan has passed a clean slate law. So juvenile expungement of a record is done much quicker and even automatically. So juveniles do not have to pay attorneys or come back into the system in many offenses. It's after a certain number of years, currently 2 years post jurisdiction, their cases are automatically expunged. And then there's selective expungement where you can come back even sooner to remove those adjudications. We've also done a nice job with diversion programs, like you mentioned, Sam, where someone is not convicted or adjudicated. They're given a chance to earn a dismissal of the case before adjudication. And Michigan's been very creative in some of those diversion programs. And then certainly with record keeping, we've argued to the Michigan Supreme Court on what juveniles should have to submit by way of data and fingerprints and DNA. I've been on some winning battles of that, losing battles of that. But generally speaking, an adjudication will not haunt a minor as they become adults and apply for colleges and so forth, unless it's one of those waiver offenses. And there are certain offenses that you cannot expunge and will be on their record, for lack of a better word, for potentially the rest of their life.
I think that's great to hear. Unfortunate that it would happen, but good to hear that people can grow and move on with their lives. Now, tell us about another memorable case involving a juvenile that you've handled, and maybe some lessons that you've learned from that particular instance.
Yeah, I always tell the story. I remember it vividly. I was a younger attorney, and I was retained by the parents of an 8-year-old young girl that was charged with a crime. And just the oddness of that on its face. And let me tell you, when I walked into court, and this girl was all of, I'm using my hand here, 3 feet tall and 100 pounds soaking wet. And it's just an odd feeling to represent someone that young. And that case was so sad. And eventually we got it dismissed because of age considerations and so forth. But I always think about that case and sort of the overreach of government and staining someone's life. I'm sure that's a case she'll never forget, because she was scared out of her mind as a young child facing down a judge and a system. So I always think about that case and sort of remember that case without any further details. And then I've represented juveniles who have been getaway drivers for older cousins, older brothers, and then have found themselves charged with status offenses that put them in the risk of state prison. I've had a lot of those sort of bad influence juvenile cases that have run amok for kids. I've had a lot of kids charged with those waiver offenses that we've battled like heck to keep them out of adult court and had some success there. And then you have cases that, don't make the public eye, thank goodness, because they're juveniles, but are all over, sort of the justice system in terms of what they've done. There's some interest in the cases without naming their names. And so I think about those kids because in the grand majority of them, Sam, I've never heard from them again, which, knock on wood, is a good sign, because unlike a lot of repeat clients in the adult system, for the most part, and maybe without many exceptions, most of the juveniles I've represented in 25 years, I never see again. So I think there is that notion of the system getting their attention, rehabilitating them, and it's working for the majority of at least my clients in the juvenile system.
I'm glad to hear that's been your experience. To wrap things up, what advice would you give other legal professionals dealing with, as you've described it, some of the cases can not just be sad, but bewildering, emotionally charged, and high profile? So what advice would you give them as they're dealing with their own cases in a similar vein?
Yeah, I've never understood the exact reason why, but a grand majority of attorneys that practice criminal law don't also do juvenile. If you did an internet search, we're one of, if not the only, one of few. And I just think that many attorneys are scared off by the prospect of representing juveniles, either because it's a different procedure, sort of a different feel to it, maybe not totally comfortable in representing kids that have high stakes things. I don't know the true motivation. We've always enjoyed it. I've been a prosecutor in juvenile court all the way through, representing juveniles all these years. And so I think for my best advice would be get comfortable with it. It's really no different than adult defense in terms of what your goal is to make sure you protect your client zealously, the word we used earlier. There are obviously some ethical constraints and some different feels to it. We've talked about with the parents and the different procedures and different rehabilitation goals. But ultimately, I say for those that are interested, try out a case, talk to someone like me and get some advice on it. It's not for everyone for the reasons I stated before, but it's definitely a rewarding practice area, and it's different than the everyday when you're representing a teenager charged with something than someone who's a repeat offender in adult court.
This has been Michigan Justice Chronicles with Dan Geherin. I'm Sam Henniger. Please like, share, subscribe, because we are going to keep having great conversations just like this.
It was great being here, Sam. Thank you very much.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.